Hey everybody, welcome back. Do Americans have a right to privacy? Yeah? Well, what amendment says so? Smash that like button and I'll tell you the story of the most controversial right. So, nothing in the Bill of Rights specifically guarantees a right of privacy, and yet the Supreme Court says that we do in fact have such a right. How can that be? Well, most commonly there are actually two ways to discover a right to privacy in the Constitution. One way is really simple. It's in the Ninth Amendment. The Ninth Amendment says that there are unenumerated rights that belong to the people. Unenumerated means not written down. Essentially, the first 8 amendments protect several of our rights, but the ninth is kind of a catch-all backstop amendment that says, hey, just because it wasn't named in the first 8 amendments doesn't mean that we don't have that right. There are other rights that belong to the people that aren't written down. The easiest way to establish a right of privacy is to use the Ninth Amendment to establish privacy as one of those unenumerated rights. The other way is to say that other amendments imply that there's a right of privacy. For example, the Fourth Amendment mentions the right of the people to be secure in their possessions from unreasonable searches. So you could claim that this implies that people have a reasonable expectation of privacy. Let's take a little detour for a moment though. In the last video, we talked about procedural due process, which is about the law being fairly applied to everybody. Substantive due process, on the other hand, is about whether the law itself is fair. Substantive due process allows the Supreme Court to establish and protect fundamental rights from arbitrary government interference. Just like incorporation, this is based on the Due Process Clause that prohibits both the federal and state governments from depriving a person of life, liberty, or property without due process of law. The court uses substantive due process to protect individual rights by striking down majoritarian policies as an overreach of governmental authority. Okay, with all that as background, let's go back in time to the 1960s. The state of Connecticut had a law prohibiting the sale of birth control. Doctors couldn't even talk about contraception with their patients. So 2 women open a birth control clinic, which promptly gets shut down by the state. They sue, and we have a Supreme Court case, Griswold versus Connecticut. The court struck down the birth control ban, but far more important for us was the reason why. According to the court, the law violated the substantive due process right of privacy, or said more simply, the court established and incorporated the right to privacy. The court's reasoning gets a bit fanciful, but they took the second option I mentioned earlier. They said that you could find a constitutional right to privacy implied by other amendments in the Bill of Rights. Essentially, if you squint real hard, you can see the right to privacy in other rights, like the First, Third, Fourth, Fifth, and Ninth Amendments. Fast forward to 1973, and Texas had a law banning women from obtaining an abortion unless the mother's life was in danger. A woman identified as Jane Roe sued to challenge the law as an infringement of her substantive due process rights. In Roe v. Wade, the court agreed and struck down the abortion ban, ruling that the right of privacy protects the substantive due process right of a woman to terminate her pregnancy. Abortion is obviously controversial for numerous reasons, and I don't have to tell you that people feel extremely passionately on both sides of the issue. But the controversy for the AP exam is all about the constitutional argument. The fact that privacy was used as the constitutional justification for abortion led to the privacy right becoming even more controversial. I know that the Ninth Amendment guarantees us unenumerated rights, but the fact that privacy isn't specifically listed means that it's on more precarious legal ground than the other rights. Fair or not, it just is. Now fast forward nearly 50 years to 2022, and the Supreme Court ruled on a case, Dobbs versus Jackson Women's Health Organization. Mississippi had a law that banned abortion 13 weeks into a pregnancy. This directly violated Roe v. Wade, which established that states could not ban abortion until the fetus reached viability, which occurs at about 22 weeks. In one of the most controversial rulings in recent memory, the court in Dobbs not only upheld the Mississippi law, but chose to go much further, explicitly overturning Roe v. Wade, saying that the Constitution does not confer a right to abortion. There's a ton that could be said about this. For one, the role of stare decisis and how much obligation the court has to uphold long-established precedents. Another is the debate over whether this ruling was an example of judicial activism or restraint. A person's answer probably has to do with their political beliefs about the issue. The majority opinion claimed that it was practicing restraint by returning the abortion issue to state governments, who are now able to legislate and even ban abortion if they choose. Meanwhile, the dissent claimed that the disregard for 50 years of precedent was evidence of an activist court making an ideologically driven ruling. Regardless of those issues, the fact is that in the aftermath of Dobbs, decisions about the regulation of abortion are currently left to state legislatures. Since the ruling, some conservative states have placed restrictions or outright bans on abortion, while liberal states have protected the right. One footnote for all of this for the AP exam: none of these cases are among your 14 required cases, so you don't need to know all the details like you do for those cases, but you do need to know all three of them by name and how they affected privacy rights. Well, that's it for this one. Next up, civil rights. Until next time, this has been a LaMoney production. Thanks again for watching. Be sure to smash that like button. If you haven't subscribed, make sure you do. And if you want great practice and study resources, consider checking out the Ultimate Review Packet. And I will see you in the next video.